Hello and welcome to the next episode in the Deer Street Barristers podcast series, The Advocate's Lounge. My name is Thomas Parsons Munn. I'm a Chancery and Employment Barrister here at Deer Street, and today I'm going to be talking to you about the talk that has the very catchy title of PD Practice Direction 57AC, which governs the form and content of witness statements in the business and property courts. So the essence of the practice direction is that witness statements must be the evidence of which a witness has personal knowledge and in their own words. The parties are required to only include evidence which the witness would be permitted to give if they were to give oral evidence during the course of the trial, setting out factual evidence upon which a party relies in support of their case. Now, none of that may sound very new, and indeed it fundamentally just reinforces the requirements for witness statements that are already in place under Part 32 of the Civil Procedure Rules. But this particular practice direction has been introduced because so often those rules are ignored in High Court business and property cases, with witness statements frequently being used as opportunities for parties to argue their cases and give narrative accounts of disclosure documents, leading to unnecessarily long bundles and trial timetables without actually progressing the case at all. If you are preparing or helping a client to prepare a witness statement for a trial in the business and property courts to which this practice direction applies, and I'll come on to the circumstances where it applies in a moment, the fundamental thing to keep in mind is that central philosophy that I've just outlined. If you do that, then you probably won't go far wrong. I won't dwell on the actual substantive requirements and procedural requirements of the practice direction in any great length. What I want to do in this podcast is focus on how the courts have approached the issue of compliance in the 4 or so years now since the practice direction came into force in 2021. And the case law that has come out gives us a helpful reminder of the ramifications of not following the practice direction, and indeed if you're on the other side of a case where your opponent has provided a non-compliant witness statement, the case law also gives a helpful indication as to what course of action you should realistically and appropriately follow to deal with that. So, dealing firstly then with what kinds of statements and proceedings are affected by 57AC, what witness statements are covered. It applies to trial witness statements signed on or after the 6th of April 2021 in both new and existing proceedings in the business and property courts. At present, there's no provision within the CPR applying it to any proceedings being undertaken in the county court, and that's even if they are designated by the county court business and property court work, albeit there is nothing to prevent a direction that it will apply either on the application of a party or of the court's own motion. So it's not uncommon increasingly, particularly as a lot of county court work is that has a business and property court dimension, if you will, but isn't formally proceeding in the High Court. The district judges and circuit judges will give directions requiring the parties to comply with 57AC, even if they don't have to do so automatically. So it's always worth keeping a weather eye on that in case management directions. It doesn't apply to proceedings in the King's Bench Division unless they're in the specialist list in question that is also part of the business and property court. So, for instance, the technology and construction court. Now, in terms of what we mean by a trial witness statement, the practice direction itself defines trial as any final trial hearing where all of the issues, or only one or some particular issues in the case, are being dealt with, either under Part 7 or Part 8. So it consequently applies equally to trials of preliminary issues as it does to a final trial hearing in the traditional sense. It doesn't apply to interim applications or interlocutory hearings, however. It's also worth bearing in mind, though it's too specialist to go into in this talk, that there are specific provisions applying it to unfair prejudice petitions and contributories winding up petitions as well. I will briefly just go over the content and other requirements for witness statements under the practice direction, so that what I have to say later on in this talk about how the courts have approached issues of compliance hopefully makes a bit more sense. The practice direction provides that a trial witness statement must contain only evidence as to matters of fact of which the witness has personal knowledge that are relevant to the case and needs to be proved at trial. It must list which documents, if any, a witness has referred to or been referred to for the purpose of providing evidence in the statement. It must be prepared in accordance with the statement of best practice in relation to trial witness statements, which is set out in the appendix which accompanies the practice direction. It must be verified by a statement of truth in the normal way under CPR 22. It has to include a confirmation of compliance, which is a second declaration, again contained in the appendix. And it must be endorsed by a certificate of compliance signed by the relevant legal representative, typically, of course, that party's solicitor. Whilst it doesn't mean by any stretch that these provisions can be ignored by any of the parties when preparing their witness statements, it's worth noting that these requirements do not in any way change the law of evidence, and various High Court decisions have dealt with and confirmed that issue. Simply because a witness statement fails to comply with Practice Direction 57AC does not mean by any stretch that it will be inadmissible. As with any other procedural non-compliance, the court will have to consider what, if any, sanction to apply, and unlike in other parts of the CPR, there's no automatic sanction for non-compliance. It's a matter for the court to decide what sanction to impose, if any, if it sees fit. And that's the sort of issue that will typically get dealt with at a PTR, as I said before, be that on the application of a party, or indeed to the court's own motion if it spots any non-compliance. What the practice direction does do is set out what sanctions the court can apply, and these are fairly wide-ranging and both in nature and the degree of seriousness for the party affected. The court can refuse to give or indeed withdraw permission if it's already been given at a previous case management stage to rely on part or all of a trial witness statement. It can strike out part or all of the trial witness statement. It can order that the witness statement in question be redrafted in accordance with PD57AC or as may otherwise be directed by the court. It can make an adverse costs order against the non-complying party, or it can order a witness to give some or all of their evidence in chief orally at the trial. And inevitably, as with so many sanctions and considerations regarding sanctions, a lot of the nature of the breach, the degree of seriousness, and all the other circumstances in the case and how the case is going to progress in light of this non-compliance will be weighing on the judge's mind in considering what is the most appropriate thing to do. And in the next part of the talk, we'll look at some practical examples and guidance that have been provided by the senior courts in exactly how judges have approached those issues of non-compliance. Now, case law to date suggests that the courts are generally reluctant to strike out a witness statement altogether for failure to comply with the practice direction, except in the most serious cases of non-compliance. But they may be more inclined to order the statement be partially redacted or indeed replaced with a compliant version. The cases also illustrate from the other side of the equation in litigation that where a party is served with a witness statement it believes is non-compliant, it should raise that issue promptly and in detail with its opponent and attempt to reach agreement as to how to deal with any issue before raising that issue with the court. If a party ends up raising the alleged non-compliance with the court, it will be much more likely to succeed in having some kind of sanction imposed if it does so promptly and identifies the specific passages that it alleges fail to comply. Nonetheless, it is important to avoid disproportionate satellite litigation, and the general approach in the cases has been that the closer to the trial the application is made, the more likely it is that the court will simply decide to leave it to the trial judge to decide what weight to give to any non-compliant evidence in light of any breaches of the practice direction, bearing in mind that they will have the benefit of hearing from the witness directly. In Mansion Place Limited against Fox Industrial Services Limited, a case from 2021, the court ordered redactions to both parties' statements under the practice direction to remove evidence that was non-compliant because the passengers merely commented on other documents or witness evidence or because they contained argument. Nonetheless, the judge refused to order redaction of several other passages where, for example, they made very brief reference to background matters or contained direct evidence as to a witness's state of knowledge at the relevant time. So an illustration there of the court exercising its powers to order partial redaction of witness statements that didn't comply. With regard to the question of what the party concerned that the other side haven't complied should do, in Mansion Place, the court gave some guidance, emphasising that the party should raise the issue with the other party and attempt an agreement as soon as possible. Failing that, they should seek a court determination, document-based or at a hearing, but its timing and manner should not disrupt trial preparation or cause unnecessary costs. Disproportionate satellite litigation was seriously discouraged, and it was emphasised in Mansion Place that it is often, in fact, the judge hearing a trial who will be best placed to determine specific admissibility issues rather than essentially having a preliminary hearing that will deal with the admissibility of a particular statement or not. In Curtis and others versus Zurich Insurance plc and others in 2022, the court went much further in criticising disproportionate satellite litigation generated by the innocent party, if you will, the one who was objecting to non-compliant witness statements remaining in the trial bundle. Now, although that party had made a largely successful application to strike out part of the claimant's witness evidence, the judge nonetheless ordered them to pay 75% of the claimant's costs, assessed on the indemnity basis. The justification for that was that he was dismayed that the costs incurred by both sides in dealing just with this issue exceeded £275,000, not including VAT, and found there was nothing that could possibly have justified that level of expenditure on a preliminary point of procedural sanctions about evidence. The judge considered that the application was fundamentally inappropriate and designed as a strategy to emasculate the evidence of a central witness into the claimant's case. Although there were nonetheless some good meritorious points of non-compliance, when those were set against the context of a disproportionate and oppressive schedule and could have been simply dealt with at trial through cross-examination and submissions, the judge very much doubted whether the application to strike out the witness statement in its entirety was justified, and indeed considered it most likely wasn't. The judge in that case stressed that applications for sanctions should not be used as a weapon for the purpose of battering the opposition. Parties making oppressive and disproportionate applications resulting in substantial and unnecessary costs should not be surprised, according to that judgment, to find their conduct marked by an award of indemnity costs against them, even if successful. It was emphasised finally in that case that the power to strike out parts of the witness statement will only be exercised where it is reasonably necessary to do so. So an illustration there of the need to be extremely careful when making an application to strike out or any other serious sanction in respect of a non-compliant witness statement, particularly bearing in mind what I said back at the beginning, that the practice direction is imposing procedural requirements which, although they're there for a reason, do not fundamentally affect the admissibility of witness evidence, which remains governed by essentially common law principles. Now, notwithstanding the reluctance that the court, certainly in the early days of the practice direction, showed to strike out witness statements in their entirety for non-compliance, a slew of more recent cases have started to suggest that judges are beginning to run out of patience when it comes to cases of blatant non-compliance or lip service. In the case of Fausto and another against Francis from 2024, the court held it was unable to give any weight at trial to 3 witness statements relied on by the claimants due to the significant non-compliance with Practice Direction 57AC. And this decision followed swiftly on from the decision of His Honour Judge Pearce in KSY Juice Blends UK Limited against Citra Suco, in which he suggested that there is far too much lip service paid to the practice direction by those preparing and certifying witness statement, and cautioned practitioners against assuming that non-compliant statements would not have any consequences. Indeed, the point that arises from these cases and needs to be taken seriously by practitioners and witnesses is that Practice Direction 57AC imposes requirements, additional requirements to a typical statement of truth, for certification of compliance. And there is a general trend amongst, at least certainly many of the judiciary, that if a witness or indeed their solicitor is unable to properly certify a witness statement saying, and does so saying they've complied with the practice direction when it's obvious they haven't, and should be obvious to the person making the certification that they haven't, then that is seriously going to damage the credibility of the witness whose statement that is. So what then are the takeaways from this? Firstly, trial witness statements covered by Practice Direction 57AC should obviously be prepared in accordance with the statement of best practice as set out in the appendix, and practitioners who have cases, particularly routinely have cases in the business and property courts, ought to become familiar with that statement of best practice and the requirements of the practice direction that preceded it. Indeed, in Mansion Place Limited that we referred to earlier, the court suggested that parties and their legal representatives should use the statement of best practice as effectively a checklist to avoid unwittingly breaching the restrictions regarding the content, form and purpose of trial witness statement. The best practice statement is particularly helpful because what it does is gives a more practical or real-world illustration of what the requirements of the practice direction actually are. And of particular importance, given it is typically the content of a statement which is in brief rather than the certification, is this, and if you take nothing else away from this talk, I think it would be this point that I really hope everybody listening remembers. Factual witness evidence is evidence about matters of which the witness in question has personal knowledge, and of course it goes without saying it also has to be relevant to issues of facts that the judge will have to determine at trial. A matter will be within a witness's own personal knowledge if it is something they have experienced through their own primary senses, sight, hearing, smell, touch or taste, or if it is a matter, in the words of the practice direction, internal to their own mind, for example, something they thought at a particular moment, or the reason they took a particular action or decision. The other take-home, on the other side of the coin, for a party receiving a non-compliant statement, is that they ought to reflect before taking any knee-jerk action, particularly any particularly draconian knee-jerk action, such as applying for strikeout or withdrawal of permission for a witness statement. Albeit they nonetheless need to act promptly, they need to nevertheless be having constantly at the back of their mind the question of whether it is necessary and in accordance with the overriding objective to have sections or indeed the entirety of a statement removed. Circumstances may arise where it is because, for instance, it is now impossible to deal with all matters that a witness statement raises within the trial time estimate, and the reality is that a party is going to have a determination from the court as to whether certain issues are going to remain in evidence, so they know before commencing witness evidence whether they do or don't need to cross-examine on it. But in many other instances where there are fairly obvious breaches of the practice direction, for instance, giving a summary of documents that the court is going to have to go through anyway. So in that situation, yes, the practice direction hasn't been complied with, but the reality of the situation is that the trial timetable is going to be relatively unaffected because it isn't going to add much to the cross-examination of that witness. That it would be more proportionate in those circumstances to simply cross-examine the witness at trial about why it is that they have certified that they've complied with Practice Direction 57AC when they obviously haven't, in the way that witnesses in county courts up and down the country are cross-examined day in, day out about why they've signed a statement of truth on something that they now decide is wrong. It's the same essential principle. The trend that is emerging from the case law is that whilst questions of witness credibility are always going to be being dealt with on a case-by-case basis, there now appears to be an established judicial tendency, and I don't put it any higher than a tendency, to view non-compliant witness evidence less favourably, and indeed to refuse to allow the defaulting party to recover their costs of preparing the non-compliant statement in question, regardless of whether they are successful at trial or not. I hope I've managed there to give you a helpful summary of the requirements of the practice direction where it applies, and indeed really hammered home the need to comply with it to avoid issues arising in your case that you no doubt won't need to arise when various other moving parts are all in play at trial, but also really emphasising the importance of thinking carefully and proportionately about how to go about dealing with non-compliance by your opponent so that you can deal with any issues that arise without ensuring that any judicial wrath ends up being turned on you instead, as some people have made the mistake of in the past in the cases we've looked at. Thank you all very much for listening. I hope that was useful. If you have any questions or queries or indeed want to instruct us, then please feel free to get in touch with Chambers in the usual way. We're always at the end of the phone. And stay tuned for the next episode of the Advocates Lounge in due course. Thank you. Bye-bye.